All right, welcome back. Shh. Thank you. All right. Thank you. I will resume with a brief video. The book that we published has a video series, and this is going to be a brief history of the enumerated powers. This will summarize all the cases. We'll watch for about 2 minutes.
However, the court's construction of Congress's implied powers to reach activity beyond interstate commerce has fluctuated greatly. Join me on a brief history of implied congressional powers. First, in the earliest days of the Republic, President Washington determined that Congress had the implied power to create the first bank of the United States, over the objection of James Madison and Thomas Jefferson. Second, during his term as Chief Justice, John Marshall continued the broader Hamiltonian reading of implied federal powers in cases like McCulloch and Gibbons. Third, we studied the case of Craig, decided during the Pawnee Court, which applied an even broader construction of the Necessary and Proper Clause to find an implied power to enforce the fugitive slave laws. Fourth, in DeWitt and Hepburn, Chief Justice Chase narrowed the approach to Congress's implied powers, but then in Knox, following the appointment of new justices by President Grant, the court would adopt perhaps its broadest description of the scope of Congress's implied powers. Fifth, during the progressive era, the court flip-flopped. In E.C. Knight and Hammer, the court narrowed Congress's implied powers to regulate local business transactions, but in Champion, it permitted the prohibition of the sale of lottery tickets. Then, in Schechter-Poultry, it reasserted a limit on Congress's implied powers and invalided the National Recovery Act. Sixth, the New Deal Court in Doherty ushered in a radical redefinition of implied federal powers by adopting the substantial effects test, which was then expanded further by the aggregation principle adopted in Wicker. Seventh, these New Deal doctrines governing implied powers then continued on to the Warren Court and were used to uphold the Civil Rights Act of 1964 in Heart of Atlanta and in Katzenbach, where the court added a jurisdictional hook to regulate interstate activity that used items that had traveled in interstate commerce. The Supreme Court would go nearly 6 decades before it struck down a law because it exceeded Congress's powers under the combination of the Commerce and Necessary and Proper Clauses. That winning streak for the federal government came to an end in 1995 with United States versus Lopez.
Okay. What I like this video shows is how we've not had a straight line. It's been somewhat jagged. Okay. All right. Any questions before we move on to the next topic?
Yeah, one question.
Yes.
The name of the like martial court or war court or whatever is the president?
No. It's from the Chief Justice.
Chief Justice?
So Chief Justice John Marshall, Chief Justice Sanford Chase, Chief Justice Earl Warren. It's the Marshall Court, the Chase Court, Warren Court.
And who designates that?
The President gets to pick the Chief Justice.
Okay.
The Chief Justice, okay, so I should have said this earlier. Today, the Supreme Court has 9 members. That number is fluctuated between 5 members and 10 members. The size of the Supreme Court is not set in the Constitution. It varies. By statute, Congress can change the size. One of them is the Chief Justice, and the President gets to fill that vacancy if it's open. The Chief Justice doesn't have any special powers, except he can generally assign who writes what opinion. So the presiding officer gets to pick, okay, you write this case and you write this case. Unless the Chief Justice is in the minority, right? If he's in the minority, he can't assign the opinion, in which case the most senior judge gets to assign the opinion, who's in the majority. But the Chief Justice is influential because it's called the Roberts Court, the Rehnquist Court, the Chase Court. It's called the Chief Justice.
Very good. All right, let's move on. Part 3 concerns how federalism limits congressional power. What is federalism?
Federalism describes the relationship between the state governments and the federal governments.
And usually, you say federal law always will trump state law, except in certain cases where the states actually can override federal law. Ooh. So the first one is a case called New York against the United States. New York had a problem, right? They did not have facilities to dispose of radioactive waste. Every state has this problem, right? Where do you dispose of radioactive waste? No one wants it in their state, right? So Congress passed a law that says, okay, New York, we have this problem of waste and you're not dealing with it. New York, you are required to take responsibility for all waste in your state. Any privately generated waste, New York has to take responsibility. Supreme Court said no, right? Congress cannot force a state to take an action, right? Congress cannot require a state to take ownership of radioactive waste. If Congress wants to regulate it, they can, but they can't force the state to take ownership of it. This is what's called commandeering. Commandeering, C-O-M-M-A-N-D-E-E-R-I-N-G. Commandeering. It's a concept that Congress cannot command the states to take certain actions. Okay? And then about a decade later, with another, 5 years later, we had another case, number 25, called Prince versus United States. Here, Congress tried to force state officials to conduct background checks when someone wants to buy a gun. If I go to a gun shop in Montana and I want to buy a gun, Congress said the local sheriff has to do a background check. Supreme Court said no. If Congress wants background checks, they have to hire their own officials. They cannot command state officials to do their work for them. So here we have two cases in which federal law says Congress says state do X, state says no, we don't want to do X, and the Supreme Court agreed. States cannot be forced to take certain actions. And you may think, well, Josh, why is this a big deal? Today, it's a very significant contemporary issue in immigration. Congress cannot force the states to assist them with immigration laws.
That is why some of them have been like protectors of
Sanctuary cities.
Yeah, the sanctuary cities.
Exactly. The reason why states can be so-called sanctuary cities is because Congress can't force them to become agents of federal immigration law. So this is not only a conservative issue, it actually cuts both ways. States that are liberal like to resist immigration laws, states are conservative like to resist gun laws. Federalism cuts in both directions. The next topic is a little bit obscure. The 11th Amendment, we come back to it. The 11th Amendment, recall, was enacted in the 1790s. And it basically said a person of one state cannot sue another state. These two cases, Hahn from Louisiana and Seminole Tribe of Florida, expanded that doctrine. And they said a citizen cannot sue his own state as well. Right? So a citizen can't sue another state, and a citizen cannot sue his own state. Why? Because the states are sovereign. Right? That the states have the same sovereignty that the King of England had. Therefore, the states are immune from suit. But wait a minute, what about Congress? Can Congress waive or abrogate or eliminate the state's sovereignty? The answer is no. In Seminole Tribe, number 27, the Supreme Court said that only in very rare cases can Congress get rid of a state's sovereignty. As a general matter, states are sovereign and they cannot be sued in federal court. There are some rare cases we'll talk about later, but those are the outliers. Okay. What's that rare outlier? Section 5 of the 14th Amendment. We talked about this yesterday. Let's say a state is openly discriminating against its citizens on the basis of race, right? That violates the 14th Amendment. In those cases, Congress can say, yeah, we're going to waive your sovereign immunity. That if a state is openly discriminating against a state because of their race, then that state can be sued in court for damages. But those are rare cases. In Bernie v. Flores and U.S. v. Marcin, the Supreme Court held that Section 5 did not give Congress that kind of authority. So, for example, in number 28, the case involved a religious freedom issue. What happens if a state doesn't give a church a permit to expand its church. No, the church isn't happy, but that's not unconstitutional. It's not that big of a deal. And therefore, the church cannot sue the state in federal court. And Marcin, which we mentioned earlier, that was the case I drew. Okay. Marcin mentioned earlier is about domestic violence. Domestic violence does not let you go to federal court. It's a matter for state court. That's the case I drew. My count was off by 1. That was it. All right. Let's move on. We are now moving from Article 1 of the Constitution to Article 2 of the Constitution, right? Which is the executive power. The executive power. These are the powers of the president. And these 3 cases all arose during war. And as I'm sure you know, in times of war, often the laws go silent, which is an old expression. The first case, ex parte merriment, was from the Civil War in the 1860s. The second case, Youngstown, was from the Korean conflict, 1952. And the final case, Korematsu, was from World War II. Let's go through each one at a time. During the Civil War, we had conflict between the states. Now, I call it the Civil War, but if you ask President Lincoln, there was no war, right? President Lincoln would say that the southern states were treason. They were traitors. They were acts of rebellion and mutiny, right? There was no actual war. Why? Because to declare war, you have to recognize there's a different country, right? To declare war on a country is an act of recognition that country exists. And Lincoln would not recognize the Confederacy as a separate nation. He said they're still Americans, but they're traitors. During the Civil War, President Lincoln suspended the writ of habeas corpus. And he said that he could order the arrest of anyone for any reason, and there was no judicial process. There was no judicial review. Now, we know Congress has the power to suspend habeas corpus in case of rebellion. That's in the Constitution. They can do that. But here, Congress was not the one who suspended it. They were actually on recess at the time. President Lincoln did it by himself. The ex parte merriment considered, can the president suspend habeas corpus? Now, this is not a Supreme Court decision. It's kind of a weird case. It was decided by the Chief Justice. His name was Roger Taney. And he decided it in its individual capacity, so not as the entire court. And he basically held that no, Congress cannot, the president cannot suspend habeas corpus by himself, only the Congress can suspend habeas corpus. Okay, so what happened? Did the president let the prisoner go? Not exactly. The case only involved a suit against a general, right? The general holding the prisoner in captivity. And at the end of the case, the Chief Justice did not say, let him go. He said, I find the president's acting legally, and I want to send a copy of this opinion to the president, and that's it. Sort of a weird decision. Why? Because Taney, the Chief Justice, knew if he ordered Lincoln to release the prisoner, Lincoln would have said, get lost. Get lost, not going to do it. And that would have been very bad for the court. So it simply said, I find that the president's acting illegally here, and I want a copy of my opinion sent to the president, and that's it. So it's sort of a weird case. You asked someone earlier about Jackson, right? This is one of these rare cases where the president, he didn't ignore the court. They did a mistake to say that, but he did something that the court said was illegal. He did it. The prisoner was eventually released, but not for some time. Questions on that one?
Yeah, why was the reason of only having Tony giving the opinion and not?
It's complicated, but each of the justices had certain supervisory roles over different geographic regions. And Taney had supervisory role over the courts in Maryland.
Okay.
That's the simple answer. That could be a longer answer, that's the simple one. Number 31. This was a case that arose during the Korean War, right, in the 1950s. The steelworkers threatened to strike. And the president said, no, 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 if the steel workers go on strike, then we won't have enough steel for the war. And we'll run out of steel and we'll lose the war. So what did the president do? He ordered his government to take over the steel mill. Nationalization. I'm sure many of your countries had similar experiences, right? Where basically the United States government nationalized the steel industry to prevent them from going on strike. The workers had to come to work or else they'd be arrested. The Supreme Court had a decision, this one's stunning. During the war, the Supreme Court said, no, you cannot take the steel mill. It's for Congress to appropriate property, not the executive. That only the executive can take property, not the Congress. And you know what happened? President Truman agreed, and he gave back the steel mill. That's rare. During a war, the court says you can't do this, and the president in the middle of the war says, okay, fine, you win, and he gave up control of the steel mill. Was that a question?
The Supreme Court decided that only the Congress will
Take property.
take property.
Yeah. Not the president. And as a result, President Truman gave up the mill. Now, the funny part is, the workers went on strike. And they went on strike for about 2 months, and there was no impact on the war. It's always the case, right? It's, oh my God, war, and then everything was fine. I mean, it didn't really make an impact. Yes.
Yes, isn't there any option for the Congress to, let's say, ratify or bless up to an extent any action carried out in advance or before?
Yes,
the president?
Congress can give the president the power in advance to take over an industry, but they didn't do it here. In fact, the case reveals that the president asked for this power and Congress said no. The president had other powers to resolve wage and labor disputes, but they could not appropriate, they could not nationalize the industry. Good question.
But if the president was acting unilaterally, has it happened in history that the Congress has ex post
Yes.
validated?
So after Lincoln suspended the writ of habeas corpus, Congress ratified it ex post. It's rare, right? It's kind of a weird thing where they do it after the fact instead of before, but it happens.
But to that, when US has been in war, usually that some powers are grow for the executives and habeas corpus and other things, rights go less during war. Has Congress made any declaration giving powers to the executive during the war?
Yeah.
Or not?
Yes. For example, during the Iraq War and the war against Al Qaeda in the early 2000s, Congress enacted certain laws that allowed the president to detain people at Guantanamo Bay. And the Supreme Court held that some of those laws were invalid.
Okay, because of Constitution.
Yeah. The court held the reason why Guantanamo was chosen in Cuba was because it was not part of the territory of the United States. And the president thought that the habeas corpus writ would not run to Cuba. And the Supreme Court said, no, it goes to Cuba. So as a result, all the laws were found to be violations of what's called our habeas corpus clause. Grossly summarizing that joke. That was like 3 or 4 cases. The third case, Korematsu against the United States, is probably one of the most unpopular decisions in Supreme Court history. During World War II, the American government enacted a policy concerning Japanese Americans. I think someone from Japan? Japanese Americans, someone? Okay, oh, several. Okay, yeah, I took the one guy yesterday. Okay. So during the American World War II, after Pearl Harbor, they enacted a policy that affected only Japanese Americans, including U.S. citizens. And the policy had a couple of aspects. First, a curfew was enacted that all Japanese Americans had to be in their homes at a certain time. The second aspect of the policy said anyone who's Japanese Americans had to report to a certain location. They could not be on their homes in the West Coast because there was risk of espionage and sabotage. And then the third aspect of the policy was that the Japanese Americans who reported this location would be transported to these camps. They were called the internment camps. It's a history I'm sure you're all familiar with. The Supreme Court upheld 2 out of those 3 policies. The Supreme Court held that the curfew was valid. The Supreme Court held that the exclusion order was valid.
However, the third part, the internment camp, the Supreme Court held that was not valid, that the president did not have the power. Korematsu is the most famous of them. And this court involved whether Congress could exclude only Japanese Americans, no one else. And what the court effectively said is, well, racial classifications are bad, but this is really important. That in a time of war, the courts cannot question the war-making powers. They cannot question the military. And the military came forward and said, we have evidence that these Japanese people are engaging in espionage, and they're spies, right? They'll engage in sabotage. Now, we know, hindsight, that was all false, right? There was virtually no risk of these individuals engaging in espionage. It was made up. Right? I don't have another word for it. And effectively, the Supreme Court was given information that wasn't accurate, and they upheld it. Decades later, the Supreme Court revisited this and said, well, I think we were wrong. But this was a very significant decision. Now, the part people don't remember is the day, I think it was the day before, or maybe the week before, Korematsu was decided, the government abandoned the policy. They said, we're going to stop this. So it had no effect. In other words, by the time this case got to the Supreme Court, the policy was already being shut down. So the decision didn't have any actual meaningful effect, but it's still a precedent that's on the books. Although I don't think it's been overruled in a way. So any questions on the executive power? Now, there are very few executive power cases. We have 3 of them. I did them very quickly. Why? Most executive issues don't go to the Supreme Court. Generally, the president can do what he wants. So it's the rare case where the Supreme Court has these sorts of rulings. Okay, anything else? Okay, let's move on. All right, the next topic is part 5, which focuses on what's called the separation of powers, right? And this refers to the powers of the president and the powers of Congress. Before we were doing what's called vertical separation of powers between the states and Congress, right? The states here, Congress here. This is what's called horizontal separation of powers between the Congress and the president, who are on the same level. Okay? The first case is called Marcin against Olson. And this case involves what's called the independent counsel. In other words, can you have a prosecutor who investigates the executive branch who is not entirely accountable to the executive branch? In other words, most prosecutors work for the executive branch, and if the executive branch doesn't like what they're doing, they can fire them. But the independent counsel is different. He was appointed to investigate the executive branch, and it's hard to fire him. And if you don't have a good reason, you can't fire him. You may be familiar with a guy named Robert Mueller, who's been in the news recently. He was not an independent counsel. He was called a special counsel, right? Robert Mueller could be fired fairly easily. But Marcin B Olson involved a different type of prosecutor, the independent counsel, who was very hard to fire him. And the Supreme Court held that this is fine, that even though it's hard to fire this sort of independent counsel, it's good. There's still enough control. And you can have these sort of independent agencies which can scrutinize and even bring criminal charges against the executive branch. This is a very important case, Marcin v. Olson.
So what is the difference between this case and maybe the Watergate case?
In Watergate, the special counsel did not have protection of his office. He could be fired. And in fact, during the Watergate scandal, President Nixon ordered the special counsel to be fired. This is a very big deal. The reason why we have the independent counsel is because of Nixon. After Nixon fired the special counsel, Congress enacted this law saying, no, we need protection for this prosecutor. But, and here's the big but, in the 1990s, the independent counsel was named Ken Starr. You might remember that name. He investigated President Clinton for various sex things, right? Yeah, that you remember. Yeah, Lewinsky. Yeah, there you go. You don't know Ken Starr, you know Monica Lewinsky, that name you know. Yeah, the intern. I met her once, but very nice. You did. the independent counsel statute became very unpopular after the Lewinsky scandal because they spent all these years investigating sex and it was a waste of time. So in around 1999 or 2000, Congress allowed the statute to expire. It was not renewed. So we no longer had the independent counsel. Robert Mueller was appointed as a special counsel, which is much easier to fire, much more accountable. He wasn't fired, finished his job, stumbled a bit, but he finished his job.
So you said statute was not renewed? Is it
Yeah, some laws have sunset provisions where they have to be renewed every 10 years, or whatever. And Congress decided not to renew it because it was really bad, very unpopular. Even Republicans and Democrats agreed this is a bad idea. And then we all thought it was a good idea, but no, I think it's still a bad idea.
When it was first created in what?
Why? Watergate.
I'm sorry, what? That was the first time they have an independent counsel?
Marcin B Olson was the first case in the Supreme Court.
Oh.
The independent this was in 1988. The Supreme Court, I think the Ethics in Government Act was enacted in 76 or 77. So a couple of years after Watergate, Congress created this new office. Okay, so that's 33, Marcin B Olson. The next one is a case called National Labor Relations Board, NLRB versus Noel Canning. And this is a question of what's called the recess appointment power, right? The president can make certain appointments when the Senate is in recess, right? So imagine the Senate takes a month-long vacation for the summer, and then like someone dies, right? The Secretary of State dies. Does that position have to be vacant for a month? No, the president can fill position during the recess of the Senate. What if the Senate takes a break for 72 hours? They take a 3-day break. Can the president make a recess during a 3-day break? Well, President Obama tried, and the Supreme Court said unanimously, no, you cannot do it. That 3 days is too short. That by making a recess appointment during a 3-day break, you are violating the Senate's power of advising consent, their approval process. You're shortcutting it. So the Supreme Court basically said 3 days is too short, 10 days is probably okay, but we're not really sure. It's a very unsatisfying opinion. But 3 days we know is too short for a recess appointment. Why does this matter? Let me tell you. A couple of years ago, in 2016, Justice Scalia died. Justice Scalia died while the Senate was in recess. I think that was probably one of the first 5 people in the country to recognize this fact. Had President Obama wanted to, he could have probably filled the vacancy during recess. Hello, Justice Merrick Garland. He didn't. He made a promise with the Senate that he wouldn't make a recess appointment. If he would have, the Senate would have come immediately into session to block that power. But this matters, right? Is it 3 days? Is it 10 days? What's the limit? But the court said you have 3 days is too short. Any questions? Okay. The next part is a biggie. Slavery and the Reconstruction Amendments. I need to walk you through some history first, just to bring you back up to speed. We've already talked about slavery a little bit. In the Constitution, we have what's known as the 3/5 clause, right? Which is a provision that says that for counting representation, we only count 60% of the slaves. We don't count 100% of them. We also have the Privileges and Immunities clause. I think you were asking about this yesterday, which says that only citizens get certain types of rights. If you're not a citizen, you don't get these rights. It's privileges and immunities. So we have these conflicts, right? So imagine you were a black sailor from Massachusetts, from Boston, and you sail you go to South Carolina on a boat. You're a sailor, and you pull into the harbor. You are a citizen of your own state, and you have all these rights. But South Carolina says you are not a citizen, and we're going to capture you and put you into slavery. This happened frequently. So you have these conflicts between the states over who was and who was not a citizen. The second major conflict concerned the territories, right? We have these 13 states in the shore and all this land out west. When a new state is admitted, is a state going to be admitted as a free state or as a slave state? If it's a free state, then it will elect people to Congress who favor abolition of slavery. If it's a slave state, it will elect people to Congress who favored the continuation of slavery. And this was a huge controversy that was basically ripping our country apart. And ultimately it led to what we know as a civil war. So in the 1830s, Congress reached a compromise called the Missouri Compromise. Missouri is one of our states. And what it basically said is all new states north of Missouri will be free, and all new states south of this line will be slaves. The idea was, let's keep the balance equal, right? For every new slave state, we made a free state. It didn't get rid of the problem, but at least kept the state of, it kept the status quo, right? It kept things constant, right? There'd be no change. But soon this sort of compromise proved to be difficult because every new state they were fighting would be slave state, would be free state, okay? That controversy gave rise to probably one, if not the most, but one of the most unpopular cases in Supreme Court history. Dred Scott versus Sanford from 1857. If you're an American lawyer, you need to know the name of this case. It's a very significant case. And not because it's good, it's because it's bad. The author of Dred Scott was Chief Justice Roger Taney. This was the same judge in the Habeas case with President Lincoln, Merrick. Okay. What are the facts of Dred Scott? You had a slave. His name was Dred Scott. His wife's name was Harriet. He had 2 children. Dred Scott traveled from Missouri to a federal territory that was free, modern-day Minnesota. It was called Wisconsin back then. So generally, when a slave was brought to a free state, that slave became free. The expression, when you breathe free soil, you breathe the free air and you touch the free soil, you become free. Okay. So Dred Scott, after he was transported to the free territory, sued his master, a guy named Sanford, and said, I want to be emancipated. Emancipated means free. The Missouri courts ruled against him, said, no, you're still a slave. At that point, Dred Scott went to federal court. Federal court says that jurisdiction exists if a citizen of one state sues another state. So Dred Scott was from Missouri, Sanford was from New York. So generally, if a citizen of New York is sued by a citizen of Missouri, they can go to federal court. It's called diversity. But here's the question. Was Dred Scott the slave a citizen? Oh, right? Was it?
No, that would be my question, like how Dred Scott could go to federal law, whatever, if it was still being enslaved.
That's the question,
No.
right? So the basic issue here was, could someone who was a slave become a citizen of Missouri if Missouri law did not recognize him as a citizen? So the basic holding of Dred Scott's actually simple. Simple is the wrong word. It's straightforward. The Supreme Court held that Dred Scott was not a citizen. Therefore, he could not go to federal court. There was no jurisdiction. But the court did so much more than just say he wasn't a citizen. The court went like 5 million miles beyond that. Right? What did the court say? The court said that a person of African descent could never be a citizen. Even if they were emancipated or freed, they could not be citizens. I have to read that chapter if you want to read it later, but they basically said these people are inferior, that they're of a lower race, that they do not have the same decency as the white race. It's some racist stuff. I don't know the other way to put it. Just if you read it, it's a white supremacy type argument. That these people come from different continents and they should not be with us, and that they're inferior. Therefore, they can never be citizens, and they can never get the rights, the privileges, and immunities, because those are only for the white people. So even if a state says that this is a free person, they're still not a citizen.
So they create a kind of new category, or?
They create a caste, yeah. Yeah. The Constitution is silent on who is a citizen. It doesn't say. But in the Dred Scott case, the court ruled that people of African descent can never be citizens. Never, no matter what happens.
So just free people?
Yeah, but not entitled to the
They're not
privilege.
exactly, not with all the rights. given
Exactly.
by the-
They don't get to go to federal court, and they don't get these other rights. Yeah, privileges and immunities, exactly.
Even in a free state.
Even in a free state, so in New York or Massachusetts, where there's no slavery, they're still not citizens for purposes of federal law. The states can do whatever they want, but for constitutional law, they're not, because they're inferior. They do not get these rights. I'm not done yet. More. Chief Justice Taney then went another step. Earlier, I said the Supreme Court usually avoids big constitutional rulings. They try to make things as narrow as possible. Taney did the opposite. Right? He just threw a match on the kerosene. Right? He wanted to help resolve the slavery dispute. He wanted to end the divide over slavery. So what did he do? He found that the Missouri Compromise, right, where the northern states are free and some states are slaves, he found the Missouri Compromise was unconstitutional. He declared that the compromise that Congress reached was invalid, so that all states had to be slave, basically. All new states were slave. He found that, and just bear with me for a second. He argued that to force a territory to be free was a taking of property. That making a slave free was a taking of private property, because the slaves were property. The same way if the state took over your house and they didn't pay you for it, it's a taking. Taney explained that slaves were property. It's disgusting to even say out loud, right? But this was the Supreme Court. That the slaves were property, and then taking their property by the government was unconstitutional, depriving people of their property. As a result, Congress could not force the territories to be free. This was Taney's idea. We have this conflict over slavery. Let's just pick a side. It goes pro-slavery. So again, Dred Scott recognized that the people of African descent would never be free, they'd never be citizens, and that Congress cannot force the states to be free. That is up to the states to decide. Again, he reached all these very difficult questions that he didn't need to, and made these very broad rulings on really bad grounds. So Dred Scott is no longer good law. You can probably guess that. Now, why is Dred Scott no longer good law? It was never overturned by the Supreme Court. Instead, Congress ratified the 13th and 14th Amendments. The 13th and 14th Amendments nullified Dred Scott. Why? 13th and 14th Amendments. 13th Amendment was ratified in 1865, and the 14th Amendment was ratified in 1868. What did the 13th Amendment say? Slavery shall not exist in the United States. In one sentence, slavery was abolished. Well, easier said than done, but at least in paper at least. No more slaves. And then go to the 14th Amendment. Very first sentence. All persons born or naturalized are citizens of the state they live in and of the United States. That nullifies Dred Scott's holding. Now he goes to federal court because he's a citizen, right? There's no doubt that Dred Scott was now a citizen because he was born in the United States. And as a citizen, he gets the privileges and the immunities, the very next sentence. So in a very short space, the Supreme Court made its ruling, and then about 10 years later, the Congress and the people ratified the amendment which nullified Dred Scott. Right?
Sorry, you said before that the Missouri Compromise was in the 30s?
I think 1830s. You can check the year. I think it was 1830s. Maybe 40s. Might be off in the year. Thank you. But Dred Scott was wiped out by the 13th and 14th Amendments. That all persons are citizens and they get these privileges and immunities. And the states have to protect their liberty, and the states cannot deny them equal protection of the laws. Right? So Dred Scott is not a good decision to cite anymore. But the court never reversed it. It was reversed on the amendment process.
So in the U.S., you have like a dual citizenship still. So you are citizen of a state and citizen of the U.S.
There's no difference.
Okay.
The one the same, right? The Constitution says you are both a citizen of your state and of the United States.
Okay.
There are some limited reasons why,
a state may only offer certain permits to its own residents, for example, right? Let's say a state had a discount for public beaches, right? A state might give its own residents a discount for the beach and out-of-state people not. So there's some differences between which state you live in, but those are pretty rare. Or a state might want to give certain contracting benefits to companies its own state and out-of-state. There's some narrow things, but pretty much no difference. Yeah.
I wanted to ask about the Indians, because the Constitution only talks about this.
They are not citizens.
And you mentioned yet that they were not considered citizens, and are still until now they are not citizens?
By statute. Congress has created statutes that make them citizens, but they're not citizens by virtue of the 14th Amendment. So if you're a member of an Indian tribe, you can get a passport, for example, a U.S. passport, but you're not a constitutional citizen. Because you're not. The Indian territories are not considered part of the United States. They're sovereign nations. But it's weird. There's no other way to describe it. They're in the United States. They have certain citizenship rights, but they're not citizens by virtue of the 14th Amendment. Right? A person born on an Indian reservation cannot run for president, for example.
But can they be naturalized?
Yes, they can be naturalized.
So no cases have been brought before the Supreme Court by any Native American Indian?
We have this case from the late 1800s, a long time ago, that they are not citizens by birth. They're citizens. Congress creates statutes that naturalize them, but they're not citizens at birth. They're only citizens by virtue of statute.
In history, did the slaves that were not among the slaves after the amendment?
I'm sorry, what's your question?
Once the amendment was enacted, this amendment 13, whatever.
Yeah.
Were there any claims against the states?
Oh, what a good question. The answer is yes. Let me get my Constitution out. I'm going to show you something most people never even know about. Not very anticlimactic. So if you go to the 14th Amendment, I think it's in section. Where is it? Okay, section 4 of the 14th Amendment, right? If you read about one sentence in it says, neither the United States, blah, 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 shall pay, assume or pay any debt or any claim for the loss or emancipation of any slave. There were actually claims after the 13th Amendment that you took my property. And slave owners actually argued that they were required to be compensated. So section 4 of the 14th Amendment, right there in black and white, says that the United States will not pay any claims for emancipation. So that wiped out all the nullification. I actually read one article that calculated how much money it would cost. It was a significant amount of money because you put a dollar amount. There's a cost. It's ghastly to think about it. But yeah, section 4 of the 14th Amendment wiped out all the compensation claims. They put it in there quite deliberately. Yeah, most people don't know that that's in the Constitution. It's a very obscure clause, which doesn't get much attention, but I know these things. Yeah.
Yeah, I've heard recently in the news that Democrats are trying to are talking about remediation.
The reparations.
Reparations.
Yeah, I mean that would not be the constitutional issue. That's just sort of a humanitarian issue. I don't know the right word to use it. I don't have a strong opinion on that. I don't really know. But thank you for the question. All right. Anything else with Dred Scott? A very significant case. All right. So we are now going from Dred Scott. 13th Amendment was 1865. 14th Amendment was 1868. And now we go to cases decided after the 14th Amendment was ratified. And we have three important ones decided in the span of 2 years. Slaughterhouse cases, Rattle versus Illinois, and U.S. versus Cruikshank. Number 36 and 37 were decided on consecutive days, decided one day after this. They're very close in time. So the 14th Amendment says that states cannot deprive citizens of privileges and immunities. Someone asked yesterday, what are these privileges and immunities, right? This was the first big case from the Supreme Court to decide what these rights were. New Orleans, a city in Louisiana, enacted a law that said all private butcher shops must close down. That if you want to be a butcher, you want to slaughter animals, you have to bring your animals to this centralized facility and slaughter it there. The butchers were not happy. All their businesses were now being shut down. They said, you know, if you want to inspect us, that's fine, but you can't make us shut our facility. They argue that one of the privileges and immunities was the right to earn a living, the right to contract. This might be a foreign notion to you, but in America there was a very strong sentiment that people have the right to pursue an occupation, the right to make contracts, the right to engage in economic transactions. The state can't arbitrarily interfere with the rights of economic freedom. This is a concept. And they argue that this law would shut down their butcher shops were unconstitutional. The Supreme Court said no. That this phrase in the Constitution, the privileges and immunities, doesn't refer to sort of natural rights. Instead, it refers to positive rights. Rights for national citizenship. So, for example, the right to travel on interstate waters, and the right to access federal facilities, and the right to travel abroad, right? Things that are limited to the federal scope. This is a case that almost everyone agrees is wrong. They very narrowly read the Privileges or Immunities Clause of the 14th Amendment. I hate the decision. It did not get the case right. But this more or less crippled the Privileges or Immunities Clause. You have this clause in your Constitution, it sounds really good, but it means nothing, right? It protects a worthless body of rights no one cares about. The next case was decided the following day, and involves something you can probably relate to more. There was a woman, her name was Myra Bradwell. She wanted to be admitted to the bar of the state to become a practicing lawyer. And the state said, no, women can't be lawyers. And she argued, well, let me tell you the reason why. At the time, we had something called coverture. You know what that is? That when a man and woman were married, the woman loses all legal rights. Right? It's as if the woman doesn't exist, that the marriage has all the property, has everything. And so the court said, well, if a woman is married and she can't make legal contracts, how can she be a lawyer? Right? Only the husband could make the contracts for her. So this case goes to the Supreme Court, and the Supreme Court says, sorry, there's no right to pursue an occupation, you have no right to be a lawyer. So they rejected Myra Bradwell's claim. So in these two cases, the court explained that there are no sort of natural rights protected by the Privileges or Immunities Clause. It only protects positive rights in statute and federal law. Okay, make sense? Yes?
In what section is exactly said that there is immunity if you look at Article 2 of the Constitution? Where is it?
It's Section 1 of the 14th Amendment.
Oh, it's the 14th Amendment.
Yeah, there's also, so this gets confusing, right? In Article 4, there's Privileges and Immunities Clause. And the 14th Amendment is Privileges or Immunities Clause. The way I remember it is Article 4 is Privileges and A comes before O. So Article 4 Privileges and Immunities, 14th Amendment Privileges or Immunities. Okay, they're different provisions. Right, so number 36 and 37, oh yeah, sorry, in the back.
In that case, she was married.
She was married, yes.
Did you have any case where she was single?
I don't know if there were any cases for single women. I'm not aware of any, but she was married. In fact, the reason why she was married was important. Her husband trained her as an apprentice. There was no law school back then. So to become an attorney, you had an apprenticeship, and her husband was actually she worked for her to become an apprentice. And he supported her career, but it was working.
But the whole case is she was married and right, so
Exactly.
A single woman would.
I don't know if these single woman cases, but she was ultimately allowed to go. After this, the state changed direction to let women in, so I think it didn't really matter. But this is what the Constitution requires them to take this direction. Good question. All right. So 36 and 37 concern sort of natural rights, right? Rights that are not enumerated. 38 is a case involving rights that are enumerated. We have in the Constitution a Second Amendment, which guarantees the right to bear arms. We have a First Amendment, which has a right to associate with people, a right to assemble. Cruikshank is a violent case. The facts are gruesome. You have a town in Louisiana with an election, right? You have a Republican candidate who was backed by the African American community, and you have a Democratic candidate backed by the white community. There was a dispute over who won. The Republicans seized the courthouse and said, we are going to take control of this. This is our election. And then the white lynch mob lit the house on fire, and they burned them all alive. And those that escaped, they shot and buried by the river. It's a gruesome case. The federal government brought a prosecution and argued that the lynch mob deprived these people of their rights to bear arms, the right to assemble, right, protected by the First and Second Amendment. Now, this was a state lynch mob and not a federal lynch mob. The Supreme Court said, sorry, too bad, that the Second Amendment and the First Amendment only limit federal power and not state power. This was Barron versus Baltimore. We learned this an hour ago, right? That the city of Baltimore could take private property, right? They said same. 14th Amendment did not change the situation. That even though you have this 14th Amendment, the states can still deprive people of their rights. Why? Because the privileges and immunities did not include the Bill of Rights. That the privileges and immunities clause only affected federal rights, limited, but not what's in the first 8 amendments. So the states could still deprive people of their right to free speech, right to bear arms, right to religion, etc. 14th Amendment didn't change that. Now, Cruikshank is not really good law anymore. The Supreme Court has held that the states are now bound by the Bill of Rights, but that came many, many years later, right? Decades later. But in Cruikshank, they said the states can lynch people, no big deal, which is possible. Nothing in the 14th Amendment stops it. Again, all 3 of these cases were decided a couple years after 14th Amendment. 14th Amendment was ratified 1868. We have what, 73, 5, 6 years later? And within a couple years, the Supreme Court basically wiped away the 14th Amendment. They killed key components of it. The 14th Amendment was ratified in a radical time. After the Civil War was over, the southern states were not part of the government, right? They were not allowed to go to Congress. So you had these very radical abolitionists who were passing these amendments and bills. And then later, the Southerners came back in and things started slowing down a bit. So there was a lot of optimism and hope, but it didn't always pan out. So any questions on these 3? It gets worse. It gets better eventually, but this is like the harder part. Next, we'll turn to what's called the enforcement powers. So if you see in your Constitution, you have Section 5 of the 14th Amendment, right? Section 5 of the 14th Amendment gives Congress a new power. It gives Congress the power to enforce the 14th Amendment. They can enact legislation. So what's Strata versus West Virginia? Well, at the time in West Virginia, only white people could serve in the jury. If you were black, you cannot serve in the jury. Women, forget it. But white men can serve in the jury. Strata was a black guy. He was charged with murder. He actually killed his wife. And he was going to be tried by an all-white jury. And he argued, no, this is not fair. And he said, look, Congress passed a statute and said, if I'm being deprived of my rights, I can go to federal court. In federal court, you'd have an integrated jury. So he wanted to remove the case from state court to federal court so there's a fair jury. And the question was, can Congress do this, right? Can Congress remove the case? And the court said they can, right? That having an all-white jury deprives a person of his rights, and that Section 5 of the 14th Amendment allows that to happen. So he was able to remove his case to federal court. Actually, I don't know what happened afterwards. I'm researching that now. I'm not sure. But he was able to remove his case. The next case went in a very different direction. Congress enacted a law in 1875 which said you cannot segregate on the basis of race in a public accommodation. So in a hotel,